SJC-10340, Commonwealth versus Dowds.
Good morning, Your Honor.
It is a good morning, and now you can start.
May it please the court, David Nathanson from Mr. Dowds, with me as attorney Eva Jellison. The primary issue before the court today is whether the evidence that trial counsel failed to investigate would have mattered to the jury. That is, whether there's a reasonable probability of a different verdict. The evidence would have mattered to the jury. The evidence that the jury never heard was substantial, it was objective, it was credible, and most importantly, it preceded the event.
What about the motion, this was raised in the motion for new trial, correct?
Was.
And the judge made a lot of findings, or discussed the case a lot, and his impression of what was going on, and his impression of everything, and even if the expert had testified, even if all of this had been presented, that the evidence was so contrary to, because of the defendant's statements and what he articulated about being aware of everything and is making his decisions, that it would have fallen apart on cross-examination.
Well, there are certainly multiple answers to that, but even if, I'll just jump right to it. So we have 3 CAT scans showing him having a traumatic brain injury, scarring, brain atrophy in his frontal lobes. It's called encephalomalacia, and those are the areas that govern impulse control and planning and future consequences. And so what Judge Welch did was say, well, really the crux of his decision comes in conscious disregard, which was the standard for felony murder in this case. And his decision is essentially that Dowds drove and had some school, so he must have appreciated the risks to Keith Coster and chosen to disregard them. And it's simply wrong. Dowds can't be equated to a normal person possessing an 8th grade education. The evidence is that traumatic brain injury at an early age does dual damage. It impedes function immediately, but also it impedes the ability to develop going forward. So in fact, the deficits worsen. The entire point of his impairment is that he has trouble acquiring information, recognizing its importance, and reacting to it in real time. So here we have an incident that took 20 seconds, and what someone else can acquire, process, and react to in 20 seconds, Dowds cannot. And so this goes right to what Judge Welch said. So I'm skipping forward a little bit, but so the Commonwealth's argument and Judge Welch's argument for no prejudice is essentially entirely dependent on the admissibility of the statements.
The admissibility of Dowd's statements.
Yes.
Yes.
Because they show an awareness of the danger to Keith Coster. But I would say that even if his statements are admissible, the evidence that trial counsel did not investigate would have allowed him to do 3 different things in front of the jury. It would have allowed him to explain the difference between Dowds remembering that someone's on the side of the car and Dowds recognizing and processing all the implications of a man being on the side of the car for 20 seconds. It would have allowed trial counsel to explain Dowds' exceedingly long, documented reaction times all through his life. It would have allowed trial counsel to explain that Dowds' statements about his intentions may have been impaired by TBI, affecting both the accuracy of his statements and his awareness of their import. And voluntariness was, in fact, a very live issue in this case. Right? Backing up just a little, so as to conscious disregard, so what I just want to emphasize is we have this long objective documentation of frontal lobe injuries that are essentially a one-to-one correspondence with the issue for conscious disregard, whether he was conscious of the risk and whether he disregarded it. And this, Dowds eventually does make statements that are harmful on that issue after an hour in an quiet interview room versus 20 seconds in a car going 50 miles per hour.
How much information did the expert have about what he was or wasn't able to perceive? Because it seems to me that it doesn't take much at all to know that if someone's on the outside of the car and you accelerate and try to run into things, there's a bad consequence. And understanding that, assuming he has a TBI, it seems like that would manifest itself in other ways.
So, first of all, which is just a TBI, we're talking 2, maybe 3.
Okay.
Second of all, the expert certainly had all the medical records that we were eventually able to find. We didn't, one of my great frustrations, I was never able to get the 1978 medical records when the initial injury happened. We have the 1987, 88, and 91 medical records.
Was there, I thought there was something in the briefs that said he had not received treatment,
That
but
he didn't go to
that
hospital.
wasn't proven, is that it?
No, that's not true. In fact, he was in the hospital.
Oh, he was, okay.
He was in the hospital as a 4-year-old for 6 weeks, and he was
Okay. Oh,
he was actually
all right.
taken
I
away from
misread
his
that.
mother because she didn't come pick him up from the hospital. What the expert had was all those records plus his expertise, which was to say, I've studied brain injury, and the consensus is that delayed reaction time, delayed processing, delay across all cognitive functions is the primary feature of traumatic brain injury. Roy Dowds will get there eventually with a lot of things, with help, with time, but not in the space of 20 seconds. And we don't know when he realized what was happening during the course of this incident. Maybe he realized at the beginning, maybe he realized at the end, or maybe he didn't realize at all.
What's it?
I'm sorry, the presence of Keith Koster on the side of the vehicle.
Well, he knew he was on the side of the vehicle because he was trying to get him off.
Well, so again, this is the prejudice from the statements. That's what he says. And it's really, I want to point specifically to, we're moving now, I would say, from conscious disregard to the Miranda.
Well, no,
inquiry.
I don't want to.
No, okay, then I won't. Yeah, certainly.
No, my only point is that there was no showing that he didn't know how to drive, right? So he was driving in a way that was unusual.
Well, so the evidence is there, yes, there's evidence that he's swerving. And there's evidence that it yaws right into a curb and a pole, and Mr. Koster dies. There's also evidence that Koster is pounding on the side of the vehicle.
They're all indications.
But, and this is simply my inference, but pounding on the side of a vehicle could also cause shaking. I also, and this is one of the things I wanted to pursue before Judge Welch, and he denied me the funds for it, was I believe that there was an initial impact that may have caused some of the erratic driving that then caused the yaw. And I wanted to...
Isn't the lens not you? Isn't the lens what Judge Welch believes as the trial judge a reasonable jury would have thought this evidence would have affected them, right? Isn't that what we're looking at?
So there's sort of two answers to that. One is he's not allowed to make credibility determinations about the expert, which he did. And so his, his decision, to the extent it relies on that, is erroneous.
Why is he not allowed to make credibility determinations?
Because Roberio says you can't.
I'm not so certain about that.
Well, what Roberio says is if that your expert comes forward with an admissible opinion, then then the trial judge can't say no prejudice because no juror will ever believe this.
But Ribeiro was an all or nothing, though. Ribeiro was, I know Ribeiro well, but if a defense attorney comes to a trial judge with new expert testimony, and the expert wants to testify that I looked at the astrological charts and there's no way this person could have done it because they're a Virgo. The judge can say that's nonsense. That wouldn't affect a jury. So there has to be, the judge has to have, when they assess the impact on a jury, they have to have in their mind how good of an expert opinion is this.
So in your example, that opinion is not admissible. And that is absolutely.
As long as it's admissible, you think judge has to say, I can't consider the value or how good this opinion is when I weigh it to a reasonable jury?
So the Commonwealth has latched on to footnote number 9 in Lang to say, well, there must be some consideration of the strength of the defenses. And so what that's talking about is comparing what the defendant actually did at trial versus the strength of the defense that he has now presented. In Lang, the defendant had a very viable self-defense case, whereas in post-conviction proceedings, he did present an NGRI-type defense, but the defendant also told the judge, or told the evaluators, I'd never let this happen. I'd never let it go forward. That's precisely not what we have here. In fact, trial counsel pursued the issue of concussions causing a head injury. Trial counsel pursued the issue of intoxication. He was focused on intent. He was focused on conscious disregard. He just didn't do what he should have done. And so there's Judge Welch's poo-pooing of the opinion is essentially a credibility determination that's inappropriate in that context.
Well, I think actually he found the expert to be credible.
Well, he found him.
He's, in his own Judge Welch turn of phrase, he says quite something fellow,
Yes.
right? Right.
Right.
Compelling.
Right.
Right, but he said the jury wouldn't have believed him because he was paid, and it was after the fact, and he was naive. And that's not an appropriate evaluation of prejudice under this standard. And while we're talking about prejudice, I think it's really a good segue into the Miranda issue, which yes, Your Honor.
If I can stop you before you get there. So I'm trying to figure out your argument. Is it your argument that you need to win on both voluntariness in order to knock out his statement, in order to win on the issue that it may have mattered to a jury had they not heard the statement, as to whether they would have been in doubt about conscious disregard for the risk to human life?
No, Your Honor, and I hope I answered that when Justice Cipher asked me about it. It absolutely would be much better if the statements were out. But even with the statements in, trial counsel still could have explained to the jury, both in a humane practice situation, but also telling the jury, using this testimony to explain the difference between Dowds remembering that someone's on the side of the car and him processing what that really means in the real world, that this creates a consequence, a real danger. This is precisely his deficit, predicting consequences. So that would have been information for the jury, even with the statements in.
We get so few of the cases where we have not determined as a matter of law that the crime creates a conscious disregard or creates a risk to human life. This is not one of the crimes which would, as a matter of law, do we ask the jury to determine from the underlying facts whether it would involve a disregard of the risk, or are we looking for the intent or the knowledge of the defendant?
So it's a subjective inquiry, if that's what you're asking,
So we're asking whether this defendant
yes.
himself consciously disregarded the risk of human life in committing the unarmed robbery.
Right, and in fact, it's implicit in the terminology. It's a conscious disregard, right? So, as to Miranda, again, very similar, Miranda is a subjective inquiry, and here there were multiple factors that combined that would have thrown substantial doubt on the validity of Dowds' Miranda waiver. We've talked about some of it, executive functioning. So he has problems with idea generation, attention, problem solving, indifference to consequences. He has impaired verbal reasoning, which Judge Welch noted, but then never analyzed. He has lifelong apathy and depression, inability to use initiative. He has low IQ, testing in the intellectually disabled range. So again, trouble acquiring information, understanding the importance, identifying and solving problems, predicting what would happen, or even caring what would happen. And that's precisely what his type of brain injury is called. It's called apathetic traumatic brain injury. So these are all factors that Judge Billings never heard when he heard the motion to suppress. In fact, he asked trial counsel, do you have any medical records to back this up? Then you're saying he might have had a concussion. Trial counsel said no, and that was the end of it. But there are additional problems with the Miranda waiver in this case that feed into those deficits that we've talked about, but are coming from a different place. The police trivialize the Miranda waiver as paperwork, and that's the Reed technique. And the Reed technique is designed to break down the resistance of normal people. It's worse when it's applied to Roy Dowds, who has a problem with apathy and initiative and verbal reasoning and predicting consequences. He's not affirmatively asked to waive his Miranda rights. This is precisely like Clark, 461 Mass 336. Having these rights in mind now, do you wish to speak to me? And this court said, that's not an affirmative waiver. That's sort of halfway there. And then tying it all up is Mr. Dow's response, which is equivocal. I don't think it really matters, here or there. That's apathetic traumatic brain injury at work. Trial counsel didn't raise any of these issues. So there are multiple grounds for suppression, and obviously we've talked about it. If they were raised, they would have kicked out some very damaging evidence and created a reasonable probability of a different verdict. Now, assuming that the statements go to the jury and there's a voluntariness inquiry. So the standard, the court was asking in one of the previous cases, what is the standard? And the standard that I've sort of drawn from the cases is that the statement can't be the result of manipulative inquisitorial activity such that the defendant is deprived of, quote, unconstrained autonomous decision, and that comes from the Bay case. And I'd say there's a strong concern here that Dowds could not resist two experienced investigators based on who he is. They used minimization of the offense. They used misinformation about the strength of the evidence that they had. They suggested that he could be questioned until he talked. They said that he needed to tell them what happened. That's on page 33 of the record appendix. They told him it was important to him to talk about whether he knew Keith Coster was on the car. It was not important to him. They told him he wasn't going home tonight. Like Bay, and I think it's pretty significant, the police implied that admitting to the crime but that he didn't mean it would gain him some leniency, when in fact that sunk him. It would enable his conviction of felony murder. So what we have here is impairments causing him to wear down and give up. And you add in his lifelong problems with depression, at least 4 involuntary psychiatric commitments as a child. And he begins passively endorsing a number of damaging police statements. You'll find that on the record appendix around the bottom of pages 39 through 42. I would say that that's the breaking point. And that then snowballs into the more damaging statements. And this is something that's really concerning to me, is there are these long, awkward pauses in the interrogation, if you listen to it, which the jury did, which make Dowds sound like he's a mastermind, like he's a criminal, he's a calculating criminal. What's, let me think out what's the best answer. That's not what's happening. We know from his history, from all the medical records, he's just trying to catch up. He's trying to figure out what's happening.
Can I ask you about extreme atrocity or cruelty?
Certainly.
So you've got the Canine factors, right? And I guess my question is, if you factor in the fact that he's got this impairment, does that only go to the consciousness of the suffering, or does that go to all three factors?
So there's two ways that the impairment would affect extreme atrocity, in addition to what Your Honor just said. One is it goes to the impairment of the second-degree malice that's necessary for extreme atrocity or cruelty. But it also, there's this sort of pop-up Canine factor that comes from the Rutkowski and Gonzalez, I think, cases, where it's an additional eighth Canine factor that the jury is asked to consider when they go through the list of evidentiary factors as to extreme atrocity or cruelty. You may consider mental impairment in determining whether the defendant committed this murder with extreme atrocity or cruelty.
Now, that instruction was not asked for here.
It was not.
In Rutkowski, was it asked for?
I don't believe it was. I believe that was a substantial risk case.
Substantial risk or substantial likelihood?
A substantial likelihood, Your Honor, yes.
All right, thank you.
Thank you.
Ms. Semel?
Good morning. May it please the court, Catherine Semmel on behalf of the Commonwealth. I also would like to focus on the second prong of the Safarian standard. And I'd like to start with a statement because I agree that it's important. And I think the question was a good one, like how much does that impact the later? Yes.
Could you start, I'd rather start with the crimes for a second. I'm trying to understand, if he's got this substantial mental impairment, on the felony murder, we've got that conscious disregard for life, whatever the conscious disregard for human life. That has to be analyzed, right? And it's do you agree that it's a subjective, individualized inquiry?
I do.
And then under the atrocity analysis, we have to do this separate mental impairment analysis, right?
I'm not sure how separate it is. I know that sometimes that the court has talked about the conscience of the community, but I really think it's using that to evaluate the factors. And this court in Oliveira said specifically that it is most pertinent to the indifference prong of the Canine factors, that it would have understandably less impact on the other factors. And
But there seems to be this additional inquiry and that we have to do on mental impairment in and of itself, separate from the Canine factors. Do you disagree with that? Because I'm just trying to, if I accept the defendant's position that this guy has a serious mental impairment that no one knew about, arising from these 3 traumatic brain injuries, I'm trying to understand how we get to first-degree murder under either of these 2. And I'm having trouble doing it when no one's analyzed this.
in reviewing the cases, I'm having a little trouble myself, because I think that at times, like in Rutkowski and Gould, I think both, there was some reference to the mental impairment being used to assess the Canine factors. And there are other times when the courts discussed it almost as though it's a freestanding inquiry. I think it makes the most sense in using it to analyze the Canine factors because you have to reach them.
But it doesn't really matter, though, because at least on some of the Canine factors, suffering of the victim, which you have here, it doesn't matter. But more importantly, under felony murder for conscious disregard, you have that issue, right?
Yes. Yes, Your Honor.
I guess one short version is, can your extreme atrocity theory survive if it did not in Rutkowski?
I think it can in this case. I think that the issue in a couple of cases, such as Rukowski, has been how pervasive the mental impairment was to the crime itself. I think that came up in Barry as well. In this case, it has more of an ancillary role. If it has, to the extent it has a role, it has a more ancillary role. He didn't steal the car because of his mental illness. The issue is, was some aspect of his awareness affected by his mental illness? And I think that for that reason, as well as many reasons stated by Judge Welch about the inherent internal defects in the opinion, that I think the extreme atrocity can survive. And certainly our only argument on extreme atrocity, look at the prosecutor's argument, was the extent of the injury.
But you also have the impairment effect in malice for atrocity cruelty too.
And, we haven't talked a lot in this case, and we've been doing this case for a long time, my brother and I don't think there's been a lot of talk about malice, and I was thinking about that, and I think the reason for that is that there really hasn't been any suggestion from Dr. Brower, there wasn't any suggestion that the defendant couldn't form intent. And of course, that's indicated by his statement.
Was that part of Dr. Brower's opinion? No?
I'm sorry?
Dr. Brower never talked about intent?
I don't think he did. I mean, he definitely talked about conscious disregard.
Right.
And that's where he focused with regard to the felony murder. And he touched a little bit on the Canine factors, specifically the pain and the conscious disregard. That's the wrong word, but you know what I mean. And I don't think he talked a lot about intent.
But I mean, one difference, of course, is that the jury was told they may consider mental impairment in deciding the issues of malice, but they were not told they may consider mental impairment in deciding extreme atrocity or cruelty.
That's true. They were not.
Apart from that, we do have the jury instruction problem with that theory.
Right. So I think if we look, taking aside the mental impairment, which of course is a big central issue, and just looking at the error from the actual trial of not giving that instruction when we agree it should have been given. At trial, it was really had to do just with intoxication. And I think when you see that the jury convicted the defendant of the other offenses, the larceny, the armed robbery, the felony murder, all of which did have correct instructions as to the intoxication, then I think you can very easily conclude that that had no impact and that we're really just talking about how mental impairment might have figured into it. If I could go back to the statements for just a minute, I think that, because I do think that they are important and they play into the rest of the trial, the question is how would testimony like Dr. Brower's have impacted the outcome of that motion to suppress the defendant's statements? And in considering that, I think you have to look very closely at what Dr. Brower said in his testimony, and he was very equivocal in his testimony about how the defendant's mental impairment may have affected voluntariness. He talked about it raising concerns, that his statements may have been the result of compliance or suggestibility. They were very equivocal, and contrasting them to kind of unusual findings we have in this case because of the other issues that were raised from Judge Billings, where he specifically points out not only that it didn't seem involuntary, but that there were specific things that the defendant did over the course of that interview that were calculated. And even Dr. Brower, when questioned about it, acknowledged that they showed that the defendant was engaging in self-preservation, such as when he declined a breathalyzer because he was afraid he was going to get into trouble for drinking, all of which is discussed in his statement.
Although it's kind of odd, he's just stolen a car and he probably killed somebody, and he's worried about a probation violation for drinking. I'm not sure that follows, that shows he's capable of much thought.
Well, I think, it's an instance of people controlling what they can control. That's how I would explain it. But certainly the fact that at the beginning, he very clearly stated, I can't help you, I don't remember what happened, then discussed all the facts of the day, and then eventually it became clear that he remembered exactly what happened with regard to Mr. Coaster in the car, and that he acknowledged that he was trying to shake him off. And I would just note that there was testimony from bystanders that would support that who saw the car moving in a way that they described as, that was shaking as though somebody was twisting the wheel back and forth. Obviously not as potent as Mr. Dowds' own statements, but there was also testimony about that. And I would just refer the court to Judge Billings' statements. He quoted the defendant's response to the waiver question as finding that it was an unequivocal waiver. He found the minimization inconsequential. And I think that these minor things that the defendant wants to raise now are completely contradicted by the fact that the defendant repeatedly corrected the police officers who were questioning him about minor things, but he was not going with the flow. When they said he ran into a pole, he said, "I think it was a car." When they said he was running away, he was walking. There were specific times when he specifically disagreed with them, whether he was on probation or parole. This was not an individual who was going along with everything that the police said, and he was introducing the critical ideas himself about what he tried to do that day. With regard to the felony murder, I'll just say the judge who was, as the court has noted, was a trial judge in this case, found overwhelming evidence of conscious disregard. And really, once you have the defendant's statement, which is of course why it's important, that he was deliberately trying to shake the victim off the car. The one additional point, one step further, that he would understand that the victim might have been seriously injured when he did that. It's so difficult to argue to a jury that was beyond him, and I think that Judge Welch focused on a couple of things in the expert's opinion. As Justice Gaziano pointed out, he did explicitly find him credible. He just thought there were problems with his opinion, and specifically how his opinion would fit with the facts of this case and what the defendant might reasonably expect to accomplish. He talked about the expert's circular reasoning, that he took the defendant's long, continuous criminal history as proof that he, in fact, was impacted by the head injury, when, as Judge Welch noted, there are many people who persist in criminal activity even though it's not good choices for them. He relied on the intoxication. He relied on various statements. And so for these reasons, Judge Welch thought that there were some inherent difficulties with the opinion, but mostly how it would affect the result in this case. And Dr. Brower talked about concrete reasoning versus abstract reasoning. The defendant, he said, can engage in concrete reasoning. That's how he explains that the defendant can say that he can process and decide to try to get the victim off the car. And I guess the question is, well, so where does the simple understanding that what he was doing could cause injury to the victim, where does that fall? Does it fall in the concrete reasoning or the abstract reasoning? And I think that was Justice Judge Welch's point, that it doesn't require a lot of executive functioning. There's evidence that the defendant had driven before, he had stolen cars, discussed in the plural, and there was no likelihood that jurors, hearing one statement, would have credited the argument that he didn't understand what was going to happen. And I would just note that even though we're not talking about counsel's strategy in this instance, I think it's short-sighted to think that this new evidence would have just slid right in and bolstered and made better the defense that was pursued in this case. It wasn't a great defense. Some cases don't have great defenses, especially when there are, confessions. But counsel made a deliberate attempt to portray his client as someone who didn't have evil intent, who happened upon a car, he needed a car, he took it, and then it spiraled out of control. And that's a persuasive thing, not for an acquittal, but to get down from first-degree murder, absolutely.
So,
And-
so help me on the felony murder part. So if he had said this was purely a joyride, there was no intent permanently to deprive, it was just joyriding, would that fall within the felony murder?
Well, you need you need the felony, so, yes, I mean, that's how he
That's a
attacked felony
misdemeanor?
murder. I'm sorry?
That's a misdemeanor?
That if he did not have, if it was just, if he didn't intend to deprive, then I don't think you can have either unarmed robbery or larceny of a motor vehicle, which were the two possible.
So that would get him, at least as to the theory of felony murder, would get him a not guilty.
Right, and I think his theory, which he explained to the judge, was that he hoped that if they believed that he didn't have this evil intent, I think he referred to it as, in one instance, that they would essentially cut him a break and view more kindly what he did in the other, in terms of determining what his intent was or wasn't. And he did get a not guilty on the premeditated murder, which was significant because I think that was an effect of the arguments that he put in front of the jury.
Did he ask for and get a lesser included instruction on whatever the crime of joyriding is called?
I'm not sure about that, Your Honor. I know there was larceny of a motor vehicle and there was unarmed robbery, and I'm not sure if there were lessers included in.
Larceny of motor vehicle requires an intent permanently to deprive.
Yes, and the difference was first or second degree felony
Right, but
murder.
if his argument was, my guy just wanted to get home, and he had no intent to do anything other than get a ride back to Lawrence, how would the jury have, if the jury had credited that, how would they have done so?
By not guilty of,
Not guilty on, because permanent deprivation was
exactly,
identified as an element.
exactly, yes. I
And
think,
and I gather there was no independent, was he also charged separately with unarmed robbery?
yes, he was found guilty of that offense separately.
And that was
It was
dropped? that's what-
filed, I imagine, yeah, I think it was filed after the
Okay,
conviction.
but there was a separate
Yes.
indictment for unarmed robbery.
There was, Your Honor. The Commonwealth's argument as to whether the conviction was consonant with justice falls along the same lines in terms of the defendant's statements, his intent in this instance. And once again, I think it is different from, and I think it was Barry, again, where the court talked about the claimed mental impairment being very closely intertwined with the offense in that case. And whatever you think about the mental impairment in this case, I don't think it reaches that. I don't think it reaches that level. So we would ask the court not to reduce the verdict and to affirm the convictions and the denials of the motion for new trial.
All right, thank you.
Thank you.